Hi friends, today we shall discuss one of the pivotal subject important topic of criminal law, right of accused. As we know that once the person get arrested, he has some rights because he is accused only. As the allegations have been leveled against him, it does not mean that he is a criminal. Therefore, accused has got various rights under the CRPC, under the Constitution of India. The most important rights are: number one, once the FIR is registered against the accused, then if he has not been arrested, then he can prefer a anticipatory bail application before the concerned sessions court under section 438 of CRPC. In case if the said anticipatory bail application gets rejected, then he can move before the Honorable High Court for getting relief under anticipatory bail. That is also under section 438 of CRPC. Suppose accused gets arrested, then what are the rights available to him? Number one, that once the accused gets arrested, then he has got the right to get the copy of FIR, because it is his right to know what are the offenses labeled against him, under which sections he has been booked. Therefore, police officer must provide him a copy of FIR. And Honorable Supreme Court of India in one of the judgment has stated and directed that the copy of FIR must be uploaded on the website by the concerned police. That is mandatory duty casted on the police officers. However, we have seen that this provision is being violated many of the time, as FIR are not being uploaded on its website. Another right of the accused is right to know the grounds of arrest. When police officer is arresting the accused, then as to why he is getting arrested, he should know. He cannot be kept in the darkness, and police officer is not supposed to be a mute. Therefore, police officer must tell that under these offenses you are being arrested. So the grounds of arrest must be informed to the accused, and his family members or his friends must also be informed. While making arrest, a panchanama has to be prepared by the police. Then accused has got the right to be consulted from his legal practitioner, that is advocate. It means the accused has got the right to get the legal advice from the advocate, and he can appoint advocate of his choice. Constitution of India says that it is the right given to the accused to appoint a lawyer of his choice. Normally what happens when accused gets arrested, he is in the jail, he is in the police station, then police officer suggest him a particular advocate. That is not the advocate appointed by the choice of the accused. It is appointed by the police officer, suggested by the police officer. Therefore, it shouldn't happen. The accused has got the right to appoint advocate of his choice. Therefore, it is by his free will he should be left open to appoint the advocate by his choice. Number 4, right. Once the accused gets arrested, then such a accused has to be produced within the span of 24 hours before the nearest magistrate. For example, accused gets arrested in Pune by the police, then the said accused has to be produced before the nearest magistrate within the span of 24 hours. However, the said duration 24 hours does not include the time of journey. For example, if journey is taking a time of for example 2 days or 3 days, in that case that time would be excluded for the purpose of this counting 24 hours. And this provision is also violated by police officers many of the time. For example, suppose they have nabbed a person, arrested a person on 5th of January, but they will keep the person in the lodge or at private places instead of police station or in police station, but they will not show on the FIR that the person accused has been arrested by them on 5th of January, and they keep the same accused in jail for in police custody or in private places like lodge etc. for 2 or 3 days to do illegal things like taking a bribe from that. It happens, this cannot be denied in that case, and they show that the accused has been arrested on 7th of January or 8th of January, that is 2 or 3 days later. These are the illegal practices which law does not permit, which is against the Constitution of India as well as it is against this provision of CRPC. Therefore, immediately accused has to be produced before the nearest magistrate. Because of that purpose, this provision is inserted under section 57 of the CRPC. However, the time of the journey could be excluded from counting the same. Another right of the accused is that when accused says that his medical examination should be conducted and he makes a request to the police officer that to prove his innocence in future in the trial, his medical examination should be conducted, then he has very much right to undergo a medical examination, and that cannot be denied. Therefore, it is also right of the accused, because in the trial, when case goes, then that time he can prove his innocence. Once the prosecution proves his guilt, then he can, in his defense, produce the medical examination, that is medical reports. Therefore, the accused has got the right of medical examination. Once he makes a request to the police officer, then police officer is duty bound to conduct the medical examination of the accused. However, it is also right of the police under CRPC to forcefully conduct the medical examination, but we are talking in respect of the right of the accused. Another right of the accused is free legal aid. If the accused is not able to appoint the advocate of his choice, because he may wish to appoint the biggest lawyer of the country, but however he cannot afford the fees of the advocate in that case, and he is not in position to pay the fees, his financial position is weak, he is a poor, in that case, the state will help him under the provision of free legal aid that is provided under Article 39 of the Constitution of India. An advocate will be given to him to defend his case, and that will be free of charge. So the accused gets an advocate from the state, from the panel of free legal aid. Hence, even if the accused does not have the money, if he is a poor, then he can be defended by an advocate of the state, and he did not pay anything for that. That is called free legal aid. A committee is always provided to every courts that a litigant who is not able to pay, then he can approach the committee and he can submit the form that he wants to get the help of free legal aid. Now, under Constitution of India, there are some important rights, very much important rights have been granted to the accused, which are also significant to see. Number one, right against the self-incrimination, which is provided under Article 20 in bracket 3 of the Constitution of India. It means any accused cannot be compelled to be witness in his own case. Means police cannot say to him that to give evidences against himself. Therefore, accused right against the self-incrimination, accused cannot be forced to be witness in his own case. He cannot be directed or forced by the police to be witness in his own case. However, if an offense has been committed by more than 2 persons and there are no evidences, then suo motu he can come. He can give suo motu evidences. However, he cannot be forced to be witness in his own case. Again, the statement recorded by police of the confession, that is confession recorded by the police during the investigation, that is of no value from the point of evidence. That provision is already given under the Indian Evidence Act. Even if the accused makes a confession before the police that he has committed offense, then that such a confession has no value in the eye of law. It has zero value because it is presumed that the force is used by the police and police uses force, that is the presumption. However, he cannot be compelled to be witness in his own case. And right against double jeopardy, that is provided under Article 20 and sub-article 2 of the Constitution of India, which says that once the accused is prosecuted, or that is trial is conducted, accused is prosecuted, the trial results either into acquittal or conviction, then he cannot be tried twice. For example, if ex-accused has committed, there are allegations against him that he has committed murder, and single trial has been conducted and he has been acquitted. Thereafter, the state cannot once again prosecute him and cannot conduct the trial. One case, only one trial. So once the accused is prosecuted and trial is conducted, whether it resulted into conviction or acquittal, then the said accused cannot be tried twice. And the punishment, if provided, for example, punishment of 3 years is provided, then no more than that punishment can be provided, because what law says that if offense is punishable up to 3 years, for example, then no more punishment than 3 years can be provided to him. That is covered under this principle of double jeopardy. That is very significant right of the accused. And every accused supposed to be innocent unless and until guilt is proved beyond the reasonable doubt by the state. It means there is a duty casted on the state to prove the guilt of the accused beyond the reasonable doubt, and till the guilt is proved, till that time the accused shall be presumed to be innocent. Even this right is also granted as a human rights in the Universal Declaration of Human Rights under Article 11 of the Human Rights Declaration at international level. The same principle also applies here in the criminal jurisprudence. And another important right of the accused is right of fair trial and speedy trial, that every accused has got this right that his trial should be conducted in a fair way. Whatever the allegations are made against him should be informed to him. All the papers and copies of the charge sheet, FIR should be given to him. He shall be given a right, an opportunity to defend his case, and he should be given a chance to appoint advocate of his choice. So a trial should be conducted in a fair way, and it should not be biased, or no suppression should be done by the prosecution. All the documents, all the evidences must be tendered to the accused so that he can have a proper defense to defend himself by his advocate. Not only the trial should be fair one, however the trial should be at speedy level, as there is a proverb that delay in justice is equal to injustice. For example, X person has been tried for offense of theft, and the maximum punishment under theft is only 3 years. However, his trial takes more than 3 years, 4 years, 5 years, 6 years in that case, and he does not get a bail for 1 year. In that case, that will be against the interest of the accused. Therefore, a trial should be conducted in a speedy way. And recently, since last 15 years or 20 years, the state has provided a trial, speedy trial, and also established the special court for conducting speedy trial for that, so that the trial should be conducted in a fast way, and trial could be concluded either way, conviction or acquittal, but no more consumption of the time is allowed. And there is a judgment of Husainara Khatun versus State of Bihar delivered by the Honorable Supreme Court. In that case, it is clearly stated that the trial should be speedy and it should not consume much more time. Otherwise, delay in justice is equal to injustice. That will happen. In that case, the Honorable Supreme Court said that those persons who were languished in the jail since long, their trial was taking too much time, then the Honorable Supreme Court of India has given a direction that the trial should be conducted in a speedy way. So new courts have been established by the state to conduct the speedy trial so that the justice could be given quickly. In offences against woman and child, and the trial court conducts the cases in a very fast way. So this is the also one of the important right of the accused. Another right, when the offence is bailable, and then if the offence committed by accused is bailable, then the accused has got the right to be released on a bail. It is matter of his right, and there is no discretion left with the judges. In the matter of non-bailable cases, it is the discretion of the judges whether to grant a bail or not. Then each case differs from another case. Therefore, the circumstances and fact of the case would be taken into consideration by the judges while deciding the bail application in non-bailable cases. In non-bailable cases, it is the discretion of the judges whether to grant a bail or not. However, in the matter of offense, bailable offences, it is matter of right. It is the right of the accused to get the bail. Even the police officer can grant the bail in bailable offences, whereas in non-bailable offences only court can grant the bail. And in case if the accused arrested in illegal manner, when the particular provisions are not applicable against him and he has no involvement in the offence, then in that case, such accused can always move the Honorable High Court under writ of habeas corpus. Writ of habeas corpus says that produce the body of the person. If any person has been illegally detained by the statutory authority or even by a private person, in that case the court gives direction to the respondent, that is those who have detained the person accused, to produce that person before the court. So in case of illegal detention, always the accused can move the Honorable High Court under writ jurisdiction and can file a writ of habeas corpus. That is also right granted to accused. And in case if the accused is arrested and his liberty gets affected, and if he is innocent, then definitely he can file a case against the state to get the damages, that is compensation from the state. In such a cases, the writ is also maintainable against the state, and there are also cases in which the court has granted the compensation to the accused. However, all the cases have not been considered in an equal manner. For example, MLA was detained in the jail, then he was granted more compensation. An ordinary man was detained in the jail, then he got less compensation. There are number of cases delivered by so many courts in India. So accused, if gets arrested illegally, then he can also file a case to get the compensation. Arrest is very much important because why? It connects with the liberty of the accused. It damages the reputation of the accused. And it not only damages his own reputation, but it damages, ruin the reputation of his entire family. If a person is in the government job, in that case, the arrest affects him. In case if he is going to apply for the government job, the arrest affects him. Therefore, these provisions are very much important. Now I would like to sum up this topic today. Hope that I have covered the many rights of the accused granted under CRPC as well as rights granted under Constitution of India. Thanks.